Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others aspiring to be them can follow in their footsteps.
Okay, folks, welcome to another episode of Latte with a Lawyer. I'm your host, Jonathan Brickman, and today we have an interesting guest here from Louisiana, Mike Gertler, and it's his own law firm, Gertler Accident and Injury Attorneys. Welcome to the show, Mike.
Thank you, Jonathan. It's a pleasure to be with you.
Excellent. So I've already had 3 cups of coffee. How do you get started since we're Latte with a Lawyer?
I had my latte this morning, obviously, but
nice.
I do have my cappuccino every morning to wake me up and look forward to it.
Excellent.
Start thinking about it in the middle of the night, actually.
Do you really?
Yeah, really.
That's a high-class problem, a cappuccino instead of just
yeah, well, in New Orleans, our coffee is very strong. So to have something comparable, you have to have a cappuccino.
There you go. And the other drinks are pretty strong there too. I can remember having a couple of hand grenades.
Yeah, well, I can't remember that from my standpoint. Too far back.
Yeah, that's right. I've only been there a few times in my life, but it's a fun place.
It's a great place, Jonathan, to eat and to drink and just enjoy yourself. So please come back often. Next time, please look me up.
Yeah, no, I will for sure. So tell us about what kind of work you do and how you got started.
Mm-hmm. Well, actually, I got started when I went into practice with my father, who at that time was a practicing attorney. He had been a judge. He retired from the judgeship to run for mayor of the city of New Orleans in 1969. He was unsuccessful. So he called me up and said, "Son, how would you like to go and practice with me?" And that's when the beginning of my real career. And from there, I got involved in asbestos litigation, but from the standpoint of respirator liability, we do a lot of product liability cases involving negligent design and construction of products. And this involved a respirator used by asbestos workers and silica workers to protect them from the effects on their lungs. And actually, my first case that I tried in federal court was against a manufacturer of a respirator. And it was a very interesting case. And thank God it was successful and started a whole career for me in products of that nature.
Okay, yeah, I've talked to a few attorneys around the country that do cases around mesothelioma. So, but you were focused on the product, not.
That was my initial introduction into my career. I ended up, then becoming known as an asbestos lawyer, which involved mesothelioma. And so I handled a lot of cases directly against the suppliers of the asbestos, against companies that utilized asbestos in the production of their materials. For instance, we had Johns Manville plants here, we had Celotex plants, we had National Gypsum plants. And eventually these workers all developed some form of asbestos disease. Yeah. The most tragic is the mesotheliomas.
Wait, so what's the difference between asbestosis and mesothelioma, or are they the same?
No, they're not at all the same. Asbestosis is a respiratory disease, somewhat similar to COPD that you get from smoking. So it involves scarring on the lungs and results in shortness of breath, limitations of that. So mesothelioma is one of the worst cancers you can develop. And that cancer is caused by exposure to asbestos.
Okay.
And so it's a much more tragic, serious, and, fatal disease.
Oh, I see. But they're both from exposure to asbestos, yeah.
Both
I worked in the construction industry for a long time, so I had a good bit of exposure to the topic. It was very topical when I was involved, and there were quite a few cases around that that I had to deal with on the construction side, practically speaking. And
that's interesting. Yes, it was. What years we're talking about?
it would have been in the early 90s.
The 90s. So
Yeah.
I'm doing this type of work in the 70s and developing information that was never previously provided by the asbestos companies about these risks of disease from asbestosis and mesothelioma. So for me, it was like, oh my God, really? This causes this kind of disease and nobody's told anybody about it? And these workers are exposed and have no idea that 10 years, 15 years from now, they're going to have these tragic diseases. So
Right.
it motivated me, tremendously, Jonathan, to be one of the earlier pioneers, so to speak, in this type of litigation involving that. And of course, a lot of the companies ended up going bankrupt.
They were Canadian. Weren't there a lot of Canadian companies?
Yeah. Oh, yeah. There was, Canadian for mining of the asbestos, particularly. So, it was big business at one time, my friend.
Oh,
Like tobacco, which I was also involved in the tobacco litigation. Here we had a class action in Louisiana for medical monitoring of for tobacco disease. And it was basically the same thing. The real information wasn't divulged until ultimately the government got involved and, revealed that tobacco smoking, cigarette smoking was so deadly. And of course, everything has changed now.
Oh, yeah. It's interesting. It's interesting how long these things stay covered up in the.
Covered up is exactly,
right?
Yes, sir. It's exactly the word. Why, Jonathan? Because of one word. It's called money.
Money.
Follow the money, my friend.
That's right.
You will find the culprit, believe me. So, and huge amounts of money were involved too.
Huge amounts.
Yeah, a lot of businesses, a lot of people making money.
Yeah, for sure.
A lot of people dying as a result.
So these are class action.
The asbestos litigation was what's called mass tort.
Mass tort, yeah.
Mass tort's different from a class. A class involves similarly situated people experiencing the same problems.
Mm.
In asbestos disease, you have a variety of injuries, a variety of damages, and it's not all the same. So each individual had to bring a separate case, and then they're all brought together under the heading of mass tort.
Oh, I see.
And then maybe one court handles all of the discovery and all of the preliminary information, and then maybe try a case or two to, get an idea of what would happen. And then it goes to the individual courts.
I see. So is it fair to say that class actions is a subset of mass torts?
Yeah, I don't know if it's a subset so much as it's just a different type of litigation. The class action is handled by one judge throughout all stages. And then, there's one trial because it can apply to everybody. And the mass tort, the only difference is that one judge is only handling all of the discovery, preliminary matters, and then possibly one or two cases as a demonstration of whether there's liability or not. So it's a twin brother or sister of each other, I would say.
Got it. Do you attend these big conferences, the MCMP?
Used to, yeah.
Okay.
Used to, not so much anymore.
Yeah, why not anymore?
Well, I mean, I'm up in age, my friend. You're a young man. I just
you look pretty young to me. You look pretty young.
I had my 76th birthday this year, so working on 77, I hope, and turning it over to my son. So I have two sons in practice with me. My oldest son is 50. My youngest son is 41, and trying to give them more responsibility. Doing my best, Jonathan. It's not easy. You think you know it all and you've done it all, and who can do it as well as you? Nobody. But
Right.
you find out that's not true. Everybody moves on. So I'm doing less and less actual litigation right now.
Okay. Got it. And I mean, so how did you, so it was just by chance that you landed into this area,
Yeah.
Okay. Are there other things that you do besides related to
Now,
expenses?
yes, I do still product liability. I do a lot of knee replacements that are defective and
Okay.
there are problems with. I do hip replacements that are defective, a lot of medically, related equipment. Then my son does a variety of product liability involving things that explode in household activities. He could probably address that a lot more effectively than I can, but they're essentially product liability cases.
My wife just got 2 knee replacements, so I hope she doesn't have a problem.
I hope she doesn't, and most people don't, but then occasionally there are some products that hit the market. For instance, in knee replacements, the government agency that normally approves these kinds of devices, they don't independently investigate safety and effectiveness. They give them an approval, FDA approval, which is based on the fact they're similar to prior products on the market. So the real test is when they get out on the market and people start using them. And if there are an extraordinary amount of problems, then they look into them and we find out, oh, they should never have been on the market in the first. But hopefully she'll be fine. If not, you have my telephone number, don't you?
There you go. I'm glad to. I would imagine, the success is somewhat maybe related to the person too, right? It's hard to pin it completely on the product because the mechanics are different for people and, their behavior, et cetera.
Well, that's true, but there is an obligation to warn and to warn certain people who have certain issues, weight issues, age issues, a variety of issues that maybe this isn't the product for you. And then of course, the doctor makes that decision and hopefully is not motivated solely by money. And then he selects his patient accordingly. Sometimes it's more than that, without getting technical. There's a lot of components involved, for instance, in a knee that are made of plastic or polyethylene that are made of metal and titanium, various types of metals. And when they get into the knee and you start moving around, if you start shedding those products too soon, if the plastic sheds into your knee, then that causes problems. And you can't always predict that, but the way it's designed affects that. So if the product's designed in such a way that a lot of the polyethylene or, for instance, plastic sheds off into your knee, that causes inflammation. Oh, that now causes bone resorption. Oh, that now causes more. So you can see that the design of the product has a lot to do with how it works as well.
Got it.
So, it's an interesting area that I got involved with, but I also do, personal injury situation. I don't do car accidents. I don't do that anymore for a couple of reasons. It doesn't motivate me, but beyond that, the law has changed so much, Jonathan, and all of these television commercials that are so deceptive. And
you mean commercials by the lawyer?
Other lawyers.
Really interesting. I'd like to hear about that.
Yeah, very, very deceptive. And then also on the other hand, Jonathan, and I'll tell you why I think they're deceptive, but on the other hand, they've captured the market. So if you have $1 million a year to spend or more, you can attract people to your law practice for auto accidents. I mean,
Yes.
they're not interested in your qualifications. They're interested in seeing some, and I would call them outrageous advertising that, is designed to just attract your attention. That's the whole point of
Right.
the advertising. But the way, if you really want to get me upset, and if you really want
I don't want to get you upset, but I am interested in this because we do a lot of work with attorneys that are testing their advertising. And I know why they do it, right? Obviously, they're trying to increase intake and get, but you're saying, I mean, what you're suggesting is there's maybe a little unethical to get business. Yeah.
I think so. I mean, I think I could blame a couple of former justices of the Supreme Court and a couple of other judges for allowing, under the premise of the First Amendment, to say anything just about, and the bar associations don't control the advertising so much anymore. They feel intimidated to let the advertisers do almost anything. And the advertisers that now what they do, Jonathan, is they show a very healthy looking, very, youngish type person, attractive person who gets there and says, I got $350,000. Just call Joe Blow. You want your 350? Go call Joe Blow, And they don't give you the injuries. They don't give you any reference point. They just like, I got 300, I got 400,000. It's so terribly deceptive, and it makes the law practice, used to be a profession, into some sort of disgusting business kind of situation,
How do you stop that? I mean, you're free to bring suit against anybody, and the other side has insurance, right? So it encourages people to act like that.
It really does, and I don't know that I haven't figured out the way to stop it. I've gotten a couple of contracts that they use and complain to the Bar Association about the contracts themselves. And in one case, the Bar Association investigated it for 3 years. It was obviously a unethical contract without going into details, but it was unethical. The Bar Association 3 years later concluded it was unethical, but only gave them a private reprimand. So if you only get a private reprimand, you can't expose it to the general public, and you've accomplished nothing. And so, that's just one example. But other than that, there's not much you can do about it, because the Bar Association permits those ads, to be run. And the Supreme Court has said, yes, you can run just about anything. It's First Amendment. So I can't sue them saying, you violated the First Amendment or privacy or whatever, because they can do it now. And it just seems so unfair to me to tell somebody, without telling them the injury, Jonathan, just say to them, come get 350,000. I just use that number as an example. Come get it. You got it? Well, no, you don't, because it doesn't account for the fees involved. It doesn't account for the expenses involved. And by the time you net it out, it may be 150,000 based on a 300. I mean, it just doesn't give any information at all about reality and truth. And we have a lawyer here that, all of his posters are one call, that's all, come get it. I mean, give me a break. I'll work my butt off every single day on behalf of our clients. And And then only after working hard for years do I get a reasonable settlement or judgment in a case, So you've got me upset now. I need to.
Oh, I'm sorry. We can pivot from here. I mean,
No.
so I mean, you're doing good work and you're getting business from, doing good work and getting referrals.
Yes,
Yeah.
referrals. Referrals are the only thing we have going for us right now. And we've done very well too. I mean, we just settled a nursing home case in the office for over $1 million. And it was a result of, hard work. It took years of appeals and et cetera, et cetera. And I'd love to put that on television and say, we got $1 million. And it really is easy. Come call us, but I would be lying to them. That is not true. It's taken a humongous amount of work to achieve that result. And even in the best of circumstances, Jonathan, when you have a good liability case, 99% of the time, the defendant is going to find a way to defend that case. And you're going to have to really work hard to keep.
Oh, yeah.
Yeah. So, that's pretty much the way I have become, unhappy with the practice of law over time.
Yeah. And your work is all on contingency. Is that right?
All contentions.
All contingency. Yeah.
Yeah.
So how do you prepare for those cases? How do you get ready and make sure you have the best argument?
It's a good question because, I mean, we used to do it differently. We used to hire a lot of people who provide advice on how to select a jury, how to present the case appropriately, get some professional input from people who do marketing and advertising and understand. But, I didn't find that was making a big difference. I thought that, using your own instinct, when you're picking a jury, kind of, your basic questions. So you have to look at them and see how they react and how they respond. And so you have to do a lot of this based on just instinct. And then you have to write your opening 10, 15, 20 times sometimes till you feel like you've gotten the right information. Same thing with your closing. You have to meet with the witnesses. You have to meet 3, 4, 5 times, go over their testimony, make sure they understand, what is expected of them, what they should know, what they shouldn't say, because it's totally irrelevant and inappropriate. So, you're always, trying to prepare as best you can. But you never know when you walk in the courtroom, there is a certain amount of instinct that you have to apply to a case. Yep. That takes experience. That's another thing. Nobody asked the lawyers on television to talk about their own experience. I know at least 2 or 3 who have never been in a courtroom before. So they hire former justices or they hire people to go to court, but there's no information about their qualifications. And what's more important, Jonathan, than experience in life? To know how to deal with a situation, how best to deal with it. It's not 100%, but it certainly helps.
Absolutely. So do most of you, but I assume you're like most plaintiff attorneys, most do not go to trial, right? Most settle?
Right, most settle, but they settle for an amount that's based on the quantum searches you do in your area to make sure that they are appropriate, not just settle to settle.
Yeah, I mean, it's always the threat of going to trial, right? You're right at the brink of going, so you're pushing the
95% of all cases do end up settling. One side or the other comes to the realization that they really don't have the better part of the case.
Right.
But the problem is from the defendant's standpoint, there are a lot of very fine defense lawyers. How do they make money, Jonathan? You think they make money because they settle right away?
No.
No, they make a lot of money just doing all of the necessary things that you would do to confirm what the case is all about, et cetera. Many unnecessary things, but that's how they're incentivized to make money.
Right.
And
Yeah, maybe that side should be fixed. I mean, you're fully aligned with your client because, you get paid based on the outcome, whereas the defense side is billable hours. Maybe that needs to change.
yes, it's a little better in federal court because there's a little bit more involved early on where a magistrate gets involved and, there's some
Yeah.
discussions early on. State court, it could drag out for years.
Right. And so they're in their best interest to drag it out for years.
Precisely.
Yeah.
Precisely. And they do it.
And they do it.
For
Yeah.
instance, I do medical malpractice as well. So medical malpractice in Louisiana involves the appointment of a medical review panel, initially 3 doctors to review the case and provide their opinion. Of course, you can still reject their opinion. You can still go to court, but they can then come and testify in the case to support whatever position they had taken in the panel. So what happens then is you would assume if 3 doctors, one appointed by the plaintiff, one by the defendant, one by both of them, comes to a conclusion that malpractice occurred, you would assume you'd settle right away, right?
Mm-hmm.
But don't ever make that assumption, Jonathan, because there's no money in it for the defendant.
Right.
If they settle right. So that case might drag out for a year or 2 before it properly settled. But the whole purpose of the panel was to encourage early settlement, based on the panel's decision. That hadn't quite worked out that way.
Yeah. Yeah.
Nothing that forces them to come to a settlement. Ultimately, they generally do, but
Well, if you push going to court, does that incentivize them to settle faster?
if the court gives you a reasonably early trial date, let's say within a year, you using that term very loosely, it helps get the case. So the sooner it gets to trial, the sooner the real evaluations begin of settlement.
Yep.
But I'm telling you, Jonathan, cases drag on for years.
Yeah.
And there's no incentive to settle till you have a trial date.
Yeah, and you take all the risk. I mean, it's interesting. I mean, yeah, there's a lot. I mean, these are not easy things to fix. But I mean, you're taking all the risk, right? Because time is not your friend on these, and you're spending a lot of money to get
correct.
Yeah,
correct. And the experts these days have realized they can make a lot of money, so they charge exorbitant amount of money, and there's a lot of money involved. And yes, it's very frustrating. My dad was a judge. He was a fabulous judge. Not that I'm prejudiced at all, but he was a fabulous judge because he did hold the parties to the dates that he assigned for, ending discovery, getting, their experts and so forth. And his docket was almost 100% current because of that, because as you pointed out, you have a real firm trial date, you can get some serious settlement discussions going.
right.
And, not all judges do that. In fact, now the judges, which is a horrible situation, they say you have to complete discovery before we'll even give you a trial date. So what happens then? Defendants drag out this discovery. Oh, we're not finished yet, Judge. We want to talk to Joe Schmo. Oh, by the way, it has nothing to do with it, but we want to talk. So they'll drag discovery out for a year or two before you even get a trial date.
Well, it sounds like your dad was doing it right. So why couldn't Why couldn't that be more best practice or normal practice?
Correct. Yeah, I wish, well, that's a whole nother complaint I have with you.
I'm learning a lot from this conversation. It's interesting. Yeah.
And what's happened too is a lot of the judges, unfortunately, here in New Orleans, we elect our judges. So you can elect a judge who has no experience at all on the bench.
Oh,
And you end up with a judge who doesn't know what to do, or how to do it. And that's a very unfortunate situation,
Mm.
if he or she is politically connected, if she's, at the right place at the right time. We have a few of those who have never been to court, never tried a case. There's no qualifications. People don't appreciate that in general. I mean, the lawyers do, but
Right.
the general public doesn't. So she's rather attractive. She seems like a nice person. So let's vote for her.
Well, we've seen what happens when you do that, don't we?
Yeah.
We've
Yeah.
all seen that.
Oh, it's horrible.
Electing the wrong people for all kinds of reasons. Yeah.
Oh, horrible, horrible.
Oh, yeah.
I should be appointing everybody who gets into public office, right? And then we'd have it right.
I think I would rely on you based on this conversation.
Well, thank you. I don't think you'll have to worry about that.
Well, New Orleans has interesting politics anyway. I mean,
Mhm.
your former mayor's pretty a vocal guy.
Yeah, we've had some, it depends on who you're referring to, but we've
Well,
had
he's in
some,
the wait. He's in the administration now.
yeah, you talk about not Landrew,
Yeah, yeah.
oh, yeah, he was fine. He really did, I think, upgrade the position. Depends on what party you're
Yeah,
in.
exactly. Depends on what party you're
All
aligned
of
with.
that, but we didn't have, problems. We had one mayor who went to jail, that's Van Nagan, who everybody thought was going to be a great mayor because he came from a business background, but just because you come from a business background, apparently doesn't change your views of money. And so he got caught stealing a lot of money and went to jail. Mark Morial, you probably have heard that name. I don't know if you have, but he's now heavily involved nationally in some organizations. I'm not sure the name of it, but it's a very prominent Black organization. He's done very well for himself.
Yeah.
But you never know, John. You never know.
Yeah, you never know. Anyway, well, we'll try to wrap it up here. But what I want to ask you about is, and I'm curious, based on the conversation, your view on technology and do you use it in the practice, or are you still relying more on sort of, your instincts and?
Yeah, I guess for my age category, you tend to not be as involved in technology. But I have the benefit of my son being here. So it helps me. I just tried a case about 6 months ago where there was a lot of technology involved in the presentation of the case. Out-of-state witnesses now can testify through Zoom.
Yep.
And don't have to fly down and be participating. That's a real benefit. The presentation of the case, was done by presentation of exhibits through technology, and that certainly is a benefit. I'm not as comfortable with it. I'm still, old school. I still like to, draw and diagram and paint my own, exhibits and so forth and so on. But the progress has been tremendous, and it really is.
Yeah.
I think overall can be really beneficial. Jurors can see things and you can show things that just are amazing now.
And you see more impact with that in the courtroom?
I think so.
Yeah.
I think so. I think people now are more adapted to it too. So, people want to and are accustomed to technology now, and so you have to use it.
Yeah, yeah. And your sons are using it more?
Yeah.
I'm guessing? Yeah.
Yes, yes. Yeah, that next generation is definitely using it more. So
Yeah, yeah. Well, I mean, even, listen, I'm old compared to, the young guys starting now too, but I try to stay current with it because otherwise you become a dinosaur quickly.
oh, yes, absolutely. So that gets us back to the original question about how long I've been practicing and, at what point I am now about trying cases, which is, less and less.
Yeah, yeah, yeah.
And part of it is due to the technology. I'm just not capable. If it wasn't for my sons, or if I had hired people, yeah, I couldn't do it, myself.
Got it.
It's nice to be able to be proficient at it yourself too.
Yeah. It's nice to be able to have your children come into the practice and take it over. That's great.
Yeah, I can remember when my dad and I got together, and that was when the computer first came into existence for use, and he would tell me, I don't want to use it. That's not good. It'll never work, Mike. That'll never work, And lo and behold, here we are totally dependent on the computer.
Oh yeah, absolutely. Anyway, all right. Well, listen, I'll wrap this up here. But if somebody wants to get in touch with you and want to learn more about your practice, what's the best way to get in touch with you?
They
Pick
can
up the phone and call you?
directly. That's the good old fashioned way. So they're more than happy to. They can use my email. I actually do read emails, so I can respond to anybody who's interested in anything. And particularly the shortcomings of the lawyer advertising.
Excellent. Good stuff. Well, listen, we'll wrap this up here, but I want to thank you for being with us. Again, this is Mike Gertler from Gertler Accident Injury Attorneys in the great state of Louisiana.
Yeah.
And this has been sponsored by EmotionTrac. So, and we use artificial intelligence technology to gather insights from nonverbal communication that lawyers use for preparing for mediation and trials.
Thank you.
Thank you very much.
All right. Bye-bye.